Yeah. Also, violation of this order is a Class C felony. Right. If you have at least two previous convictions for violating a protection order issued under Title 7, yes, 10, 26, or 74 of the RCWs. Yeah. Now, this whole idea of the individual, right, just arbitrarily being arrested by those that are in the police department. Yeah. After I had emailed them from November 15th of 2015 that my right to due process is being violated. Yes. That the petitioner didn't sign it, so it looks like she wasn't in court. No. There's forgeries on the protection order, there's misrepresentation, deception. But since they're in the police department, what did they decide to do? Yes. They would not admit the evidence exonerating me, Brady. Poop. They said I was twice there, yes, violating the restraint provisions, yes, at 7:47 a.m. and 4:48 p.m., yes. And then they said, ouch, that what did I do? Did I in any way touch the alleged victim? Oh, would have been a Class C felony. Yes, it would have. Just touching an individual, which could be considered assault, could have poked her. Now, I know I inform you of the crime of the false arrest, false imprisonment, and then I inform you that though it says it's a gross misdemeanor, yes, serious crime per se, you decide to not get an actual signature of a superior court judge that's going to hear the case. Yes. Because you, as an officer, did actually take a statement from the alleged victim that I've never seen. Yes, and you took pictures of all the bruises that had been suffered. Now, when I went through the mental health evaluation, oh, it was the city of Squim that said I'm going to have a mental health evaluation without a signed warrant from a judge saying it's a Class C felony. I did email the public defender's office about the oath or affirmation necessary so as to not violate Amendment number 4 of the United States Constitution. Yeah. And since there's no police report, pooch, there's no actual documentation. The petitioner didn't sign the protection order. Forgeries were used to issue it, and there was no due process to myself. It seemed in the mental health evaluation. Well, let's look at the 2-count criminal complaint. Shan't we? Let's say Brett Roberts talks to somebody in Brennan, Washington, and says, well, Mr. Budnick allegedly violated the restraint provisions of the protection order. They issue a 2-count criminal complaint against me, yes, without a signed statement from the victim, without any pictures, without a judge themselves signing a warrant for my arrest, yes, without me having any law enforcement involvement, without anybody questioning me of where I was at on June 16th of 2017. And when I had sent 2,000 emails that day, ooch, probably the day before and the day after. Now I can get you every email. But I have to have a mental health evaluation for knowing I was in Port Angeles, sitting in front of the Masonic Temple. Yes, at the Senior Center, as I had done every day after I'd sent a million emails about my rights.